Great. Well, I think that's probably everybody who's here. No doubt there'll be some late joiners, as there usually are. First, thank you, everybody, very much for coming along and attending. We're very pleased to join you for yet another webinar by Zoom, which we've all got quite used to by now. The topic of this webinar is the shape of things to come, looking to the future, and in particular, getting back to the office and various factors that are going to be relevant to that in employment law. As you can see, we are practicing what we preach. We are back to the office. We are doing a webinar, all three of us here in the same place. I'm joined by my colleagues, Alex Kennedy, who is an associate with us at Gannons, been here a little while, and he specialises in employment law and commercial litigation, and also by my colleague Yasmin. Yasmin has just completed her training here with us as a solicitor and qualified as a solicitor this week. So congratulations, Yasmin. We're very proud of her. She's also going to specialise in employment law and disputes. I'm going to introduce and do a little bit of talking, but I'm going to let Alex and Yasmin do most of the talking. The pandemic obviously has affected everybody's lives, and none more so, I say with slight exaggeration, than employment lawyers. Employment law has been a major feature of the pandemic for not just employment lawyers, but pretty much everybody, whether employers, employees. It's affected everything. But things are changing now. Things are getting back to normal, as the government tells us, although we're yet to see how that goes over the winter. What we do know is that some changes are coming. We are preparing for the end of furlough, and Alex is going to talk about that in particular. There's an increased focus on agile working. Flexible working, working from home, different hours and so on. And those are presenting new challenges for employees, which we're going to talk about. We're going to touch on the topic of bonuses and employee equity, generally incentives to employees, which at first sight don't seem to be the same issue, but actually we're finding that a lot of employers now are asking us about how to incentivize their employees, how to possibly change their T's and C's, given that perhaps they're working more from home, out of the office in different ways. We're going to talk about managing redundancies because that is an increasing topic. We've been seeing, unfortunately, a steady stream of redundancies, and the fear is that the end of furlough is only going to increase that. We'll talk about employees misbehaving themselves and what you can do in that situation and how, if at all, that's changed in the current situation. And we will also talk about discrimination, because that's a very live topic with agile, flexible working, working from home. And Yasmin's going to give a cautionary tale or two about how you can try too hard to avoid discrimination. A couple of housekeeping points. If you have any questions, please do use the Q&A at the bottom of your screen. There's a Q&A function which we'll keep an eye on. If you have any questions, please put them in there. If somebody asks a question that you also are interested and want to know the answer to, do feel free to upvote it, and that'll promote it higher on our list. Hopefully we'll have time to answer a good few questions at the end. As for the chat function, please don't use that for questions, but if you have any problems, you can't hear us, if you define that as a problem, then please put something in the chat and we'll try and keep an eye on that throughout. I think that's all I have to say as an introduction, so I will ask Alex to kick us off by telling us about the end of furlough. Alex.
Thanks, Alex. So why are we speaking about this right now? Well, the end of furlough on the 30th of September is quite likely to be the clearest dividing line that we have between the world of the pandemic and whatever comes next. That's not to say that the pandemic is over by any stretch, but the government has made very clear that they would rather not legislate for further lockdowns, further furloughs, etc. So the expectation is that the 30th of September is the clearest sort of watershed line between the pandemic and the recovery. So what's actually happening on the 30th? Well, broadly, after the 30th of September, employers will no longer be able to recover that portion of their employees' wage costs for those who are on furlough. Furlough has been, I suppose, winding down for a little while. I suppose starting with the introduction of flexible furlough last year, through to the increasing amounts that employers need to contribute, both in terms of national insurance, pension contributions, and then over the summer, this gradual ratcheting up of the contribution from employers. The reason the government has structured it like that is to try and encourage employers to bring back people in a sort of a staged manner, rather than suddenly bringing back everyone all at once furlough ends. And I think by and large, from our experience, and from the experience of our clients, that is what most people have done. Most people have brought people back in stages, or perhaps on reduced hours, perhaps in part-time. That being said, the end of furlough on the 30th is quite stark. And for employers who still have people on furlough, they are faced with a very stark choice. They can either bring people back or they can make them redundant. Furlough isn't being replaced by anything, it's just stopping. So, as I say, the choices are either you can bring people back or you can make them redundant, and we'll be talking about both in this talk. In terms of timescales and in terms of deadlines, for claims for furlough over the month of August, you have until today. Today is the deadline to submit those claims to HMRC. And for claims for the month of September, it will be in a month's time, the 14th of October. So other than the end of furlough, what is new in employment law? What new law do we have to propel us into the world beyond the pandemic? Well, actually, not that much. The law on home working, for instance, is basically identical on the 1st of October as it was before the beginning of the pandemic. What has changed is the context and the lived experience of employers and employees. Millions of employees have worked from home for 18 months or more, and many of them have found that they quite like it. They have a better work-life balance. They might be able to make more time for family. They might enjoy not having to spend time and money on a commute. And likewise, many employers have found that they can operate fairly effectively without an office, and might be casting half an eye towards the future and whether they can cut costs. So while I'm sure that there will be very many people who are still very concerned about the threats that COVID presents, I think it will be those other considerations, the work-life balance, cutting costs, lack of commute, etc., that will drive what we're all expecting to see, which is a greater emphasis and a greater, I suppose, greater use of working from home and hybrid working. Clearly, this shift presents a number of challenges to employers. How can you ensure that your staff feel connected and part of the team? How can you ensure that they will be productive? Will they be adequately trained and supervised? These are just a few obvious concerns which we'll touch upon, and there are some more that we'll draw out as well. In terms of productivity, it might be that the sort of natural concern of employers is slightly misplaced. The Office of National Statistics performed a survey last year, and they found that workers who worked at least some of the time from home usually worked longer and took fewer sick days than those who never worked from home. I should say that I believe that survey was conducted before the pandemic, but nonetheless, it's an interesting finding. That being said, I don't want to completely dismiss the concerns of employers, and it takes an awful lot of trust to allow workers to operate from home entirely. And I wouldn't suggest for a moment that you simply leave them to it. while you're in the office, you can bump into someone in the corridor, you can ask them how they're doing, ask them if they have enough work on, if they have too much work on. And while everyone is working at home, it's much more difficult to have those sort of informal interactions, which are so much a part of office life. So I think employers would be well advised to incorporate more formal catch-up sessions, etc., into their working week, even if that means putting in a regular meeting into people's diaries. As a related point, there is a concern whenever people with large teams have teams dispersed across the country. It's perfectly possible that employees will never meet one another. So how do you, as an employer, promote a sense of team spirit and camaraderie between all of your staff? I don't think there's a single correct way of doing this. And employers will probably want to employ a variety of tactics, be it catch-up sessions, physical meetings, if people are willing. And I think it is important to try and build in a sort of a more formal structure, again, to replace those informal interactions that you get in an office environment. A particularly acute concern is how you can manage and supervise staff so that mistakes aren't made that are costly and risky to the business. Just to draw an example out from our own industry, the insurance providers for solicitors have increased premiums for professional negligence claims during the course of the pandemic. Their theory is that junior staff, junior associates and trainees are not being as closely supervised by senior associates and partners as they might normally be. And therefore, they are more likely to make mistakes, and therefore it is more likely that people will raise professional negligence claims. I should say that's not an experience that we've seen at Gannons, but it serves to illustrate the point that employers do need to think very carefully and very proactively about how they can ensure that staff are adequately supervised. I think the best way of tackling this is to make sure that staff at all levels know that it is appropriate for junior staff to sometimes have questions of senior staff. It is a part of the working experience that you learn throughout your career, and you learn from those who are more senior to yourself. So that means that employers should communicate to junior staff that they should not suffer in silence. If they have a question, they should get in contact with senior colleagues. They should pick up the phone. They should ask the question. They should not feel like they will be punished or criticized for asking the question. And likewise, senior colleagues need to understand that it is part of the responsibility of senior staff to help in the development of training junior staff. And that if they shirk that responsibility, it could be quite a serious, but perhaps a disciplinary offence. Another challenge that employers will need to consider very carefully is how to look after the mental and physical health of their employees. Employers have a common law and statutory duty to look after the health of their employees. From a mental health perspective, some of the things that we've talked about already are likely to help, but employers who want to take more proactive steps might consider appointing a mental health champion, or perhaps a tackling loneliness champion, someone whose job it is to come up with initiatives to ensure the team feel connected and no one feels isolated. In terms of physical health, I think the most obvious thing that an employer needs to do is to ensure that employees have a safe and adequate workspace. They need to ensure that their employees, even if they're at home, have a suitable desk, a comfortable chair, screens that work, keyboards that won't give them carpal tunnel syndrome, that sort of thing. An easy way of achieving this, or helping to achieve this, is to ask employees to fill out a self-assessment questionnaire so that you are at least aware of the equipment that employees are using in their own homes. And if they're not using the proper equipment, they should be, that needs to be rectified, whether that is by providing equipment directly from the employer, or perhaps by providing a stipend or allowing expenses so that employees can buy their own equipment and have that reimbursed by the company. While we're talking about equipment, another area of concern is security. So it's very likely that as employees are working from home, they will be using their own technology. They will be using their own laptops, their own computers. And this does create a problem for employers. Traditionally, whenever everyone is in the office and they're all using the staff computers, the employer has a great deal of control of what happens on those computers. It's not possible for an employee in an office usually to install a third-party app because they do not have administrative privileges, for instance. If people are using their own devices at home, you have no idea whether they are downloading something they shouldn't be downloading, or whether they are keeping up to date with their antivirus software, firewalls, etc. So I think it is important for employers to consider how they can exert at least a degree of control over the systems that are used for work. An obvious way of doing this is to provide employees with equipment, provide them with work laptops, etc. But this is obviously expensive, and there are challenges as well with, for instance, how do you recover this equipment once employees leave at the end of their employment? Another sort of perhaps halfway house might be to use cloud computing or a virtual private network, something that is protected by enhanced security. This can help create essentially a separate workspace that is and belongs to the employer, that has their own special administrative access. And so workers can't simply download whatever they want to the workspace. And this can help isolate and protect the employer against particular technological threats, data breaches, and perhaps the most prescient, ransomware. Employers should also consider whether their own employer's liability insurance needs to be updated or the coverage extended to cover workers who are at home. It's possible that once you speak with your insurance broker or with your insurer, that they cannot provide, they cannot provide particular extended coverage, in which case it might be worth considering whether employees themselves should amend their home insurance to cover liabilities while they're at home. And if this is the case, I would recommend that employers and employees have a discussion about how that is paid for. Perhaps employers could reimburse employees for the extra premium if there is any. So how do we legislate for all of these additional changes? It's likely that the employment contract itself will need to be amended if people are going to be working from home on a very regular basis or on a permanent basis. Employment contracts should always specify where the place of work is. And then for all of these other policies, health and safety policy, the point on assurance, technology, etc., these will be usually contained in the employer's policies, most obviously the home working policy, but also privacy, bring your own device, etc., etc. So it is important to make sure that the policies that you have in place are fit for purpose and are updated if needed, and we can certainly assist with that. So far, I have spoken a lot about the challenges for home working, and you might sensibly think, well, that sounds like a lot of trouble. Can I just say no if someone asks me, can I work at home? And the very comprehensive and helpful answer that I can give you is, it depends. Clearly, not all jobs can be done from home. If you are a receptionist and your job is to bring people into a building, clearly that job cannot be done from home. But most desk-based office jobs are not like that. And our experience of the past 18 months is that many of them can be done from home quite effectively. Employees with more than 26 weeks continuous employment have a statutory right to request flexible working. Now, flexible working isn't exactly synonymous with home working, but home working might be an element of a flexible working request alongside a reduction in hours, working part-time, working slightly different hours during the week, etc. The employer doesn't need to agree to a flexible working request, but it does need to point to a particular legitimate reason if it refuses such a request. So it needs to say, for instance, that it is prohibitively expensive, or the employer doesn't have sufficient other staff to cover demand, or consumer demand is such that flexible working is not possible. It might be that following COVID, requests for home working in particular become more difficult for employees to justify refusing. I think at this stage, it would be helpful to talk a little bit about discrimination, because I think that is the traditional bear trap that we are all trying to avoid by following good employment policies here. The law draws a distinction between direct and indirect discrimination. Both are designed to protect people against being disadvantaged as a result of a protected characteristic. So something like age, sex, ethnicity, sexual orientation, that sort of thing. Direct discrimination prevents employers from adopting policies which speak directly to these protected characteristics. So it is not lawful to institute a policy such as no one under the age of 40 can work from home, or only women can make flexible working requests. And we don't see very many claims of that sort, because employers by and large know that it's not appropriate. What we see more of is indirect discrimination. So these are policies which are not by design discriminatory, but which, when put in practice, have the effect of disadvantaging one group as opposed to another. So an example might be a policy that junior staff should work from the office. That's not necessarily discriminatory based on age. It's perfectly possible to have a very young senior partner in a firm and a young junior associate, or an old junior associate, sorry. But the fact is that most junior employees tend to be the younger employees. So a policy which prevents them from working from home is, on the face of it, indirectly discriminatory. However, it is possible for such a policy to be lawful if the employer can point to a legitimate interest of the business which is served by the policy. So an employer might sensibly argue that junior employees need to be in the office to obtain particular training and to be adequately supervised. That might be an interest of the business which is sufficient to make such a policy lawful. I say might be because there are obvious challenges to this. There's a sensible argument I would suggest is, if the junior staff have to come in for training, but the senior staff do not, who is going to train the junior staff? But I use it as an example to show the distinction between direct and indirect discrimination. So throughout all of this, I think it's worth bearing this in mind, because this is what we're seeking to avoid. If employers have a circumstance where about half their workforce are working from home and about half their workforce are coming into the office regularly, they will need to consider whether they are being discriminatory to one group or the other, or whether they are implementing policies which distinguish between one group and the other, and whether that distinction might be indirectly discriminatory if the group that is home working, for instance, share a protected characteristic, which may or may not be the case. Something we are expecting to happen in the next few weeks and months is a lot of churn in the labour market. And this is one very good reason why people might want to be quite flexible about requests for home working, etc. Because employers who resist such requests are likely to find that many of their staff move to other employers who are more flexible. We expect that there will be people who will move from offices which offer home working to those which require more office time, etc., etc. People will move, is the point. Wages remain high, and there are shortages in certain industries, especially due to Brexit. So employers will want to consider how they can best retain their staff and how they can best attract new talent. And this is where we want to touch on very briefly on bonuses and employee equity. Most people understand the principle of a bonus. It can be based in contract, it can be a contractual bonus, or it could be a discretionary bonus. The benefit of a contractual bonus, which will usually be triggered by achieving certain thresholds, or perhaps hitting certain targets, is that it will be certain. Both the employer and the employee will know what is paid and when, and what has to happen for the bonus to be paid. A discretionary bonus preserves to the employer a greater amount of control, and so it might be preferred for that reason. However, employers should remember that even the most tightly drafted discretionary bonus will not give them an absolute discretion to decide whether or not the bonus is paid. The employer cannot exercise the discretion about whether or not to pay a bonus unfairly or capriciously. They can't take irrelevant factors into account and refuse to consider relevant factors, for instance. This is known as the Braganza duty after the Supreme Court case which found it. Another way of encouraging employees to come into a company and to retain employees that you have is to offer employee equity, which I want to talk about extremely quickly. Broadly, whenever we're talking about employee equity, we're talking about offering shares or options to acquire shares in the company. And this can be very effective as an incentive because the employee will quite literally be invested in the well-being of the company. You could simply give employees shares, but there are various problems with this. How do you recover shares when an employee leaves? Do the shares confer voting rights to the employee, etc.? Usually in our experience, employers prefer to offer options to employees. So these aren't shares themselves, but the opportunity to acquire shares based on certain criteria being fulfilled. Sometimes employers will offer what are called exit-only options. So these are options which will convert to shares immediately before the company is sold, for instance, allowing employees to benefit from the sale of the company without actually exerting control over the company up until the point of sale. It's possible to structure both offers of shares and options in very tax efficient ways, in particular through EMI options, which will allow staff to acquire shares in a very tax efficient manner. And in particular, our corporate colleagues can assist you with that if you are interested, in particular, Catherine Ramsey, our new tax partner. Just before I conclude, I want to speak very briefly about redundancy. As I mentioned at the beginning of this talk, employers who are bringing people back from furlough face the choice of either bringing staff back into the fold or making them redundant. Redundancy is a potentially fair reason to dismiss someone. So even if an employee has protections against unfair dismissal, which we'll talk about a little later, a fair redundancy procedure is a potentially fair reason to dismiss someone. An employer can demonstrate that they have followed a fair procedure and that they are acting reasonably and that the redundancy is lawful by warning and consulting with employees about the potential redundancy, by adopting a fair and objective criteria for the selection of candidates for redundancy, and by considering alternative employment for the candidates for redundancy in the business, considering effectively whether that employee can perform a different role somewhere else in the company that might be suitable. I should say that this is distinct from the obligations required to make collective redundancies. That is where an employer proposes to make more than 20 people from the same establishment redundant in a 90-day period. That includes its own particular obligations to consult with the group and to notify the Secretary of State. But the important point is that the employee should have some objective criteria to consult with individuals and that they can explain to the individuals selected for redundancy why they have been selected. And this is, I think, another good illustration of why it is so important for employers to have to have regular appraisals, regular meetings with staff so that they can start to acquire this data that they might use later for a selection for a redundancy procedure potentially. I think that's everything I wanted to cover. So I'm going to pass over to Alex Kleanthos, who will talk about what happens when employees misbehave and what can be done about it. Thanks.
Thank you very much, Alex. Yes, I'm going to talk about problems with employees. We're conscious that we're talking a lot about problems and redundancies and disciplinary issues and so on. Of course, there is another side to this, which is that many employers are finding their problem is not how to get rid of employees, but how to attract them and recruit them. And we're not talking about that too much today because that isn't so much of a problem. Obviously, always something we're happy to help with, but unfortunately, the focus needs to be on when there are problems and how they can be resolved. And the particular problem I'm going to talk briefly about now is what happens when you get a problem with an employee. As Alex said, working from home a lot has different factors and causes different issues. And one of the problems is that employees are not so supervised. Now, you can get problems of performance. Employees' performance needs managing, and that you as employers are generally fairly used to doing. You know how to do performance management procedures, performance improvement plans, to speak informally to employees, if necessary to conduct a formal disciplinary procedure, give them a warning, tell them what they need to do, monitor that, perhaps if that doesn't work, another disciplinary meeting, a final warning, and carry on again, and eventually, if they still aren't improving, to dismissal. That hasn't really changed with employees working flexibly and employees working from home. Where there are increased challenges, though, are with disciplinary issues and misconduct. For example, as Alex was talking about, employees, instead of sitting in the office using their employer's machinery and equipment, which can be secured, can be locked down, IT departments can monitor it, employees at home may well be using their own equipment, which you have very little control over. Or even if they're using employer equipment, such as you've given them a laptop and they use that for work, you still have less control over it. For example, with confidential information, while software can monitor what confidential information is accessed, whether it's copied, whether it's emailed, even whether it's printed, that doesn't tell you that whether if the employee has printed something at home, they've necessarily actually disposed of it or have kept it. And it certainly doesn't stop them just simply taking photographs of the screen in the lowest tech way. So there's a lot more scope for example, confidential information leaking, for employees having private conversations, doing who knows what. And that's an increasing problem that we're seeing. What are the challenges in it? Well, ultimately, the way of dealing with it hasn't really changed, but how you go about that may have. If you think that an employee is committing some form of misconduct, one of the first things to think about is evidence. How are you actually going to prove it? And that might become significantly more difficult if they're not actually in the office, and it depends very much on the circumstances that are involved. If you do want to go through a disciplinary procedure ultimately leading to dismissal, the same principles apply as always, and there's nothing greatly changed about that. First thing to think about if you are looking to dismiss an employee, of course, is how long have they been with you? An employee who's been there for less than 2 years doesn't have protection against unfair dismissal. So that's always the first thing we look at and ask about. But there are pitfalls there. If the employee might say that their dismissal is occasioned by discrimination, then there's no minimum time period for that. Alex has touched on that, and Yasmin's going to talk a bit more about that. If the employee is going to allege that they're dismissed because of whistleblowing, then again, there's no minimum time period for that. And one fairly new topic which we're seeing coming up, and the employment tribunals have started to see now, is a claim for automatic unfair dismissal as a consequence of raising health and safety issues. So if an employee has said that they can't come into the office for health and safety reasons, broadly speaking, if they're genuine about those reasons and they're dismissed for those, then that can be automatically unfair, even if proper procedures have been followed and so on. So that's another pitfall to watch for when looking at misconduct procedures now in the slightly changed world of the pandemic. The ultimate message here is that the law on unfair dismissal basically hasn't changed. There have been no actual changes to the law. The way it's applied is broadly the same. It may well be that instead of doing, say, a disciplinary meeting in person, you're doing one over Zoom or Teams, but that's fine. There's no actual difficulty about that. It's still absolutely essential to follow the correct procedure. It's still essential to give the employee their opportunity to consider the evidence and attend a meeting and have their say. But there's no real difficulty created by dismissing employees, but there are some new challenges as a result of the pandemic. As always, if we can help with those, we're very happy to do so. I'm going to hand over now to Yasmin, who's going to talk a little bit more about discrimination and some of the problems that can arise with that, especially if you're trying a bit too hard.
Thank you, Alex. So I'm here to give two cases where companies failed to conduct a redundancy exercise fairly, despite having good intentions. Now, the first case you might have seen in the media recently is with JWT, which is a top London advertising firm, and two of its former employees. Now, it started in 2018 when a damning report revealed that the company had a median gender pay gap of about 44.7%. Now, this sent alarm bells ringing, and they hired a female creative director to try and tackle this issue. Now, in a crisis meeting, this creative director made a vow to obliterate the bad reputation of the company of being full of only white privileged men. Now, this obviously concerned a number of employees that fell squarely within that demographic, and 5 particular employees went to HR with their concerns about their job safety and security following this meeting. Now, within a matter of days, these particular employees were made redundant. There's nothing to suggest that the creative director played any role in making these employees redundant, and it wouldn't have mattered. these employees brought a claim in the Employment Tribunal, and the question the Employment Tribunal asked was whether the redundancy exercise was conducted fairly and free from discrimination. Well, the simple answer is no, it wasn't. An employment judge commented that it was the gender of the employees that was on the mind of the company at the time when making the decision to make these particular employees redundant, rather than any performance-based criteria or any other objective non-discriminatory criteria. It's also clear that the redundancy exercise immediately assisted the company in resolving the issue to a degree of the large gender pay gap problem. So such treatment amounted to victimisation of the employees, sex discrimination, and their unfair dismissal. Now, 2 out of the 5 employees that were made redundant were successful in the Employment Tribunal. The other 3 out of the 5 employees reached an out-of-court settlement. I think it's safe to conclude here that this is a very expensive exercise and a mistake on JWT's part. Now, the second case is quite interesting and involves a law firm that also failed to conduct a redundancy exercise fairly. I'm pleased to say not this law firm, and it's never happened in this law firm. So this was a case where there were 2 solicitors of similar expertise in the same department in the same office. Now, the law firm decided that they only needed 1 solicitor in this particular department. Now, we have in this case 1 male solicitor and 1 female solicitor. And the law firm applied a performance-based scoring matrix to decide which solicitor to make redundant. Now, the female solicitor at the time was on maternity leave, and she had not been at work during the period which they were using for the scoring matrix. And one particular criteria, she had not been there for the period upon which they were scoring her. And so they decided to give her full marks. Now, on that same particular criteria, the male was scored on his actual performance, which was not full marks. Now, this resulted in the male employee eventually being selected for redundancy. He scored less than the female by quite a narrow margin. Now, he successfully brought a claim in the Employment Tribunal on the basis that the decision to allow the female employee to be scored full marks was sex discrimination. Now, there are a number of things the employer could have done here to prevent this. The first would be to move the time frame which the criteria was applied to a time when the female employee was working to mirror the same as the male employee. The alternative would be to completely remove the criteria that was subject to the sex discrimination point and use alternative criteria. Now, the law provides that a woman on maternity leave must not be placed at a disadvantage, but on the same hand, they cannot be placed unfairly at an advantage. And so here, as I mentioned, the male employee was successful in his claim against the firm for sex discrimination. Now, for both cases, the Equalities Act is designed to protect all employees against being discriminated against on the basis of a protected characteristic. Now, for sex, this is male and female employees, in the same way that age covers young and old employees. Now, the lesson to be learned here is that you can try too hard, and you will want to avoid leaning too far in one direction. Now, with both cases, it's clear that the companies had good intentions, but this didn't prevent them being faced with a discrimination claim. Now, one of the best ways to avoid this is to get good advice before something goes wrong. We're very happy to help with advice on this, and we have a particular package for small to medium employers. We offer a fixed cost of £1,750 plus VAT for helping you with a redundancy exercise between 1 to 5 employees. This is obviously subject to T's and C's, but we can also do it for a very realistic price, of which, if it saves you the cost of being sued at an employment tribunal, it can be a very superb investment. Now, to move on, we have a very quick poll that I would like to start for everyone. I might have to ask my colleague to help me here, if that's okay.
Yes, let's with that. And there we go.
Thank you very much. So hopefully you can see the poll on your screen. I'll go through the questions quickly with you, and I'll go through some other housekeeping points just to give you some time to answer the poll. The first question being, would you consider a bonus scheme or giving equity incentives to employees to help move along the business? This touches on a point that my colleague Alex Kennedy spoke about earlier. The second question is, will you require employees to be fully vaccinated, or will you require them to disclose what their vaccination status is? And the final point will be, will your employees returning to work on a full-time basis, or will they be working from home on a full-time basis, or will you be having a hybrid of the two? Now, just to give you a chance to go through the answers on the poll and the housekeeping points that I'd like to just touch upon, which hopefully I think you're all going to be aware of, but it's good to be reminded in any case. It's about bringing employees back to the workplace and making sure that all employees and workers and visitors are safe. Now, there's excellent guidance on the NHS website about safety guidelines for employers. They've also categorised it into different sectors, such as offices, hospitality, retail and factories. And in essence, it's about conducting health and safety risk assessments, ensuring there's adequate ventilation, cleaning, do you have to wear PPE, is there enough hand sanitizer in the workplace? It's also good to remind employees that they have a legal duty to inform an employer if they test positive for the coronavirus and are still required to self-isolate. And as an employer, you should call the self-isolation service hub. It might be that you have to give other employees details who might have been in close contact. But given the vaccination rollout, it might be the case that if an employee is double vaccinated, they may not need to self-isolate. Now, the pandemic is still ongoing, and it's likely, unfortunately, that some employees will still continue to test positive for the coronavirus. And if that's the case, and they are unable to work from home, whether it's because they're unable to perform their duties at home or they're too unwell to work, there are a few things that you need to be mindful of. And it might be worthwhile offering employees any paid leave that they might be entitled to. And this goes as well for any contractual sick pay they might have in their employment contract. So do check your employment contractual terms. And at the very least, provided the employee is entitled to it, they should receive statutory sick pay. Now, a lot of small to medium sized employees with fewer than 250 employees may be able to claim statutory sick pay. As in, you can claim back as an employer some of the statutory sick pay. And again, there's guidance on the government website for this. Now, we're well over a year into the pandemic, and hopefully we can get back to business quickly, smoothly and safely. And with that, I would like to bring back my colleagues, Alex and Alex, to go through some Q&A and to respond to the poll results.
Yasmin, thanks very much indeed for that, and thank you also, Alex. Let's look at the poll results then and see what, out of interest, what people have come up with. I'm sure you hope you'll be interested. The first question about considering bonus schemes or equity incentives, something of a split here. 58% say we'll consider a bonus scheme. 20% will consider, sorry, oh, no, it's increased, 60%, well, another vote coming, a couple of votes, 60% would consider a bonus scheme, 20% equity incentives, 30% have never considered it before, but perhaps now you might. Requiring employees to be fully vaccinated, this is an interesting one, there's a lot of talk about this in the press at the moment. 15% say all employees must be vaccinated. Nobody says we need to see employees' vaccine passports, but 25% say we will ask employees to confirm they're vaccinated, and 60% say we do not need to know vaccination status. So no real appetite for us asking people to prove something. Most people say we don't mind. Some people say we'll ask to confirm, and 15% will require them, but are going to take their word for it. And on the third question, will your employees be returning to the workplace full-time, working from home or hybrid? working at home full time, 0%. Nobody is planning on carrying on working from home full time. I'm not too surprised. Working at the office full time, 5%. I must say that slightly surprises me. I was expecting a little higher than that. And hybrid working, 95% of people are expecting hybrid working now, which is, if that's mirrored across the economy, that's going to lead to some fairly fundamental changes, in particular for businesses like the sandwich shops around here and dry cleaners and so on are going to be in a lot of trouble, and hence having employment issues of their own. Right, if we look at the Q&A now, I think it might be good news that nobody's actually asked any questions at the moment, which I'm going to take as showing us that we've actually covered everything that you're asking and interested about, and I certainly hope that's the case. We very much enjoyed giving this seminar, this webinar. I hope you've enjoyed it too. We will send round a PowerPoint. We did prepare one, but decided that having you stare at the PowerPoint for an hour is going to be no fun for anybody. And I think there'll also be the recording available online if you want to see it again, if you missed bits, or if any of your colleagues would like to see it. Now we have had a question come in. Couple of questions coming in now. First question from Michelle, is furlough redundancy the same as standard redundancy? Alex, you want to say something about
that? Yes, I think the question here is about the amount. Well, there's two ways of approaching this question. It's either the amount that is paid on redundancy or the procedure to go through for redundancy, for making these staff redundant, the process. Okay. I think the answer is yes, it is the same. You have to follow the same process. In practice, of course, this means that because furlough is ending on the 30th of September, it's quite likely that if you were to need to make staff redundant rather than bringing them back into the office at all, that process should probably already have begun. The consultation, etc., as we were talking about before. But yes, the process is the same. There is no separate rule about how to make staff who were on furlough redundant.
Thanks, Alex. Yes, there's no difference at all. But the fact that staff are on furlough might in turn help you to propose that there is a reduced requirement, and hence a redundancy situation might exist. We've had another question. What should employers be doing around vaccine passports? Vaccine passports, well, first question, firstly, the government seems to be withdrawing from producing vaccine passports or using them in any circumstances. I think perhaps what the question is aimed at is, should employers be asking employees to show proof of vaccination? It's a very tricky one. There's certainly some scope for that in situations such as healthcare, care homes, where the vaccine status can significantly impact on patients and so on. Where people are just in an office, where you may be sitting close to colleagues, and it may be beneficial to be vaccinated. Nobody really knows yet is the answer. What is going to happen if you have an employee who refuses to be vaccinated? You don't even have to ask them, because they loudly proclaim their vaccination status and that they're not going to get vaccinated, and they haven't yet caught COVID and become very ill and changed their minds. We don't really know what the answer to that legally is. It may be that if the employee's been there for less than 2 years, for example, you might just decide to dismiss them. It may be that they can work from home. It's going to be something that's going to need to looked at on an individual basis. Unfortunately, there is no single right answer to that. And ultimately, we're not really going to know what employers can do and not get sued for until some cases have started coming through the system in months and years to come. So I'm afraid there's no clear answer to that one. Right, well, those are the questions, and it's just coming up to 11, and conscious of everybody's time. So thank you very much for attending, and we're very happy to welcome you. We do these seminars regularly, so if there are any topics that you'd like to hear from us on, for example, from our corporate colleagues, we can talk about preparing to buy or sell a business and the corporate and tax implications in that. If you want to look at giving equity to employees and how that might work, that's another topic we can cover. Redundancies in more detail, we've only touched on the surface there, but we can cover that in more detail, or anything else. So if there are any topics like those or others, please do email clientservices@gannons.co.uk, and we'll be happy to see what people want and respond accordingly. So again, thank you very much indeed for attending, and hope you have a good rest of the day. Thank you.